In this video, we shall discuss concepts of fundamental rights and various articles associated with it. What are rights? Rights are reasonable claim of a person recognized by society and sanctioned by law. Different categories of rights. They are natural rights. Rights that become available to individual by virtue of their birth are called as natural rights. Example, right to life. Human rights. Rights that are fundamental to human dignity and well-being are called as human rights. Example, right to fair trial. Legal rights. Rights conferred by law are called as legal rights. Example, patent rights. Constitutional rights. Constitutional rights are enshrined in Constitution. Example, fundamental rights. Negative rights. A holder of negative rights is entitled to non-interference, while positive rights, the holder of positive rights is entitled to some goods or service. Fundamental rights. Rights that are fundamental to our life, which are specially protected, are called as fundamental rights. These are essential for our all-round development of an individual. Features of fundamental rights, and they are: some fundamental rights are available only to citizens. Example, Article 15, 16, 19, 29 and 30. Most are against arbitrary action of state. Some limit authority of state. Example, Article 14. Parliament can amend but without altering the basic structure. Rights are justiciable, where aggrieved person can directly go to Supreme Court in case of violation. Fundamental rights in Indian Constitution, Article 12 to 35, Part 3. Article 12. Article 12 defines state, which includes executive and legislative organs of center and state and local authorities. Courts also come under definition of state only when they are performing non-judicial function. Even private bodies working as an instrument of government shall come under state. Article 13. Article 13 talks about all laws in force before commencement of Constitution shall be declared void if they are inconsistent with fundamental rights. State shall not make any law that violates fundamental rights, and it defines laws as ordinance, order, bylaw, customs that are force of law, and laws in force, that is laws made by legislature. And finally, amendment of Constitution shall not be considered as law. Cases related to amendability of fundamental rights, and they are Shankari Prasad case 1951. Here, Supreme Court held that Parliament has power to amend fundamental rights. In Golaknath case 1967, Supreme Court gave primacy to fundamental rights and held that fundamental rights cannot be amended. Finally, in Keshavananda Bharati case, Supreme Court gave a concept of doctrine of basic structure and held that fundamental rights can be amended subjected to basic structure doctrine. Thank you for watching till end. For more videos on Indian polity, do subscribe to our channel.